However, there are certain instances when the law must be utilized to make crucial decisions within the family. For many of us, the first port of call would be the magistrate's court. And there are certain applications that are, unfortunately or fortunately, familiar amongst families, such as maintenance, protection orders, legal separations, where the law steps in and seeks to strike that balance, seeks to bring harmony and fairness as much as possible. We're going to discuss those family applications in this episode of The Legal Brief. I'm your host, Ramona Farquharson. And joining me to break all of this down would be Mr. Laurel Henschel, principal of Loj Law Chambers. Thanks for having you. And Ms. C.G. Smith Curry, an associate of BRF Chambers. Thank you.
Thank you for having me.
Let's get into it because we've been, they're sitting here smiling, but we've had some real heated discussions over these topics. But let's start off slowly for our listening audience. And let's decide. We're talking about families involving children. Legally speaking, who is a child?
So, legally speaking, a child is any individual who's under the age of 18 years old. That is the legal definition of a child.
Parent.
As it relates to parents, the legal definition of a parent is the biological mother or father or the adoptive mother or father of a child who's in their custody.
Right. And when we speaking as to these definitions, I take it we are relying on the Child Protection Act?
That is correct.
Yes.
And I also need to indicate to those listening audience out there that guardians are also considered parents.
Yes. So that's good to know. So we have our biological parents as well as we can have guardians as well who are recognized as parents. So we've established who is a child and we've established parents. Now we're going to get right into this. A mother, who is the primary parent in law? Is there a primary parent? And if so, who is that?
In law, I would say that at the end of the nitty gritty, it would be the mother. However, before we could even get there,
say it like that, Ms. McCurry, the nitty gritty. Say it, be proud, own it. The mother is the primary parent in law.
In law, it is the mother who is the primary parent.
And I think we need to make the distinction as well. We're speaking about, in the context of when we're going to magistrate's court, predominantly about unwed parties.
Yes.
Because again, if we're talking about wed parties, we have the Matrimonial Causes Act, where you have joint custody, and the Supreme Court, for the most part, if there's some type of separation or need for or dealing with the family, you can certainly utilize the Supreme Court. But now we're talking about predominantly unwed parties. So we have a mother, an unwed mother. She has a child, and she's in need of assistance with that child. Practically speaking, what is she to do, Ms. Angela? How does she go about, let's say if it's for maintenance, how does she go about presenting herself or getting before the courts?
Yes. Well, the courts have made it easy for her to come before the courts. She goes into the magistrate court and she doesn't necessarily need a lawyer, and the one would be good, but you don't necessarily need a lawyer. You fill out a summons to say that I'm the mother of this child. You bring the birth certificate along with you. You fill out that form. It just will say who is the father of the child, and you bring that summons before the court and you make that application by summons to the court.
So that's good. So you fill out the application form, you go in. I think it used to be $2.50. I don't know if it's still around that, but a very nominal fee.
Sure.
You fill it out. You're then given a summons, and then you
take that summons. You have that summons served.
Yes.
And the person you declare who you believe to be the father.
Yes.
and that person will come before the court.
Based on, and that's what the summons is. You're being
Yes.
summoned to court and you legally have to appear.
Yes.
Because once that affidavit of service is in place and you did not appear, then what can be issued?
What could happen is when the mother comes before the magistrate and the punitive father, we'd say, is not there, the magistrate, once she is provided with evidence that the summons indeed was served, can issue a arrest warrant for that individual. So it is very important, once an individual is served with a summons, to be at court for a particular date and time. They attend court at that date and time.
Yes.
Because there are consequences for failing to do so.
Certainly can't bury your head in the sand. I always say we tend to take an ostrich approach a lot of times and think, oh, this will go away. No, it's not necessarily going to go away. You need to be there once you're served with the summons. And so now you've been summoned and the mother appears for maintenance, yes, or whatever assistance it is that she wants. I want to ask you, and because everybody, we have to touch it right away. In the same fashion as a mother, she can move the courts to bring the man who she believes to be the father to assist with the child. Can the unwed father also, as of right, go to the courts, fill out an application, and summon the mother, let's say, for access? She can do so for maintenance, and the issues of access will be dealt with. But can the unwed father, do they have that right as well, Mr. Henshaw?
Well, before the brilliant Ramona Farquharson came along, and when I used to go to the magistrate court, I used to fill out a form for access for the fathers, and my fathers got access as of right. But there came a young lawyer, brilliant lawyer, who decided that is not what the law said. And she was correct in her position when we read the law.
Yes.
The law does not give an unwed father the right to access. So the court agreed with Ms. Farquharson and decided that the magistrate court no longer had the jurisdiction to make an application, to hear a matter for access.
As of right. Yes.
Yes.
And so, yes, the Child Protection Act makes no provision for him to move. I think throughout the act, and again, it was something when we were going through, and it's good when you go through these pieces of legislation that comes out. Sometimes we just assume,
Right.
But when you sit down, you read it, and you go through. And I recall when we were before the Supreme Court, before the now deceased former Chief Justice, the late Stephen Isaacs. I remember going through it, and I was like, no, every provision says the mother. There's nothing for a father to come before.
No, at least not for access.
Yes, certainly not for that. So it now appears that unless and until the unwed mother brings the father, the putative father, to court for maintenance, then he can, through that avenue and through that door, then say, well, okay, I'm now before you. Hear me as to access.
Yes,
that is correct.
Yes. So that seems to be the position. Now, I have to say, even though we're going to come to reforms at some point, what are your feelings on that? And before we even get into that, we've just naturally come to a break because I know everybody's sitting up, their unwed fathers screaming at the television, saying, what is happening? How can this be the case? But again, we will give answers. We'll go through the law, not just our feelings, but what the law says. And hopefully, they may agree or disagree, but it is what it is. Thanks for joining us. You're watching The Legal Brief.
Imagine your favorite dish being cooked right before your eyes. Use your imagination and savor the flavor. Do you smell it? Can you taste it? Hold that thought. We have the right show just for you. Wednesdays at 8:30 p.m. and Fridays at 2 p.m. Dishing it up. Right here on the ZNS Network. Because only the sun covers the Bahamas better.
Welcome back You're watching the legal brief, and we're discussing family applications, in particular before the magistrate's court. And I have with me attorneys Henschel and Mrs. Smith Curry. And we reached a natural break, a point where it was revealed that unwed fathers, unlike mothers, cannot move the magistrate's court in and of themselves. They have to wait until the mother brings them before the court, and then they can assert their rights. And usually it's for custody. Just briefly, because we're going to come to reforms at the end of the segment, but I just want to know from you, and start off with you, Ms. Angel, what are your thoughts and feelings on that?
Yeah, I think it's unfortunate that an unwed father is unable to come as a right to any court, magistrate or Supreme Court, and say, I want to see my child. That's all access is talking about, saying to the world and to everyone that I want to see my child and I want to take care of my child. So it's unfortunate that he can't come to the court as a right to do that.
I think he can to the Supreme Court.
To the Supreme Court.
Yes. I think they do because they have discretion.
Yeah.
So certainly you can do so.
Yeah.
But the magistrate court, which of course is easily accessible, more accessible. Most people, whenever they have any brushes with the law, it will be with magistrate's court. So your thought, Ms. Smith Curry.
Yes, Ms. Farquharson. So my thoughts on this issue, I share the same as Mr. Hanschel in relation to this. Fathers should have a right to move the court. They are, for all intents and purposes, an interested party in the welfare of the child. And really and truly, the Child Protection Act's main focus is the paramount interest of the child. What's in the best interest of the child?
Right.
So if you have a father who's upstanding, who can financially provide for that child, who has no issue and is presently providing for that child, but for some reason just is not allowed to see his child, I feel as though, yes, he should be able to move the court, the magistrate court, in that regard.
As the host, I'm going to keep my thoughts to a minimum here. But I do hear you, and of course, there's always circumstances when that do happen. I find it to be rare,
Yes.
but there are circumstances. But again, we'll come back to that. But now that the mother, we're at the point where the mother's made the application, she served this man who she believes is the biological father. What then happens when the two of them are now before the magistrate? And usually it's court number 3.
Yes.
I believe there's court 14 as well would hear some of the matters as well. But predominantly court number 3, the family court, you're there. What then happens?
So the first thing, thank you. The first thing that actually happens is the court has to determine that the father who is before the court is actually the biological father of the child. So if, for instance, on the birth certificate, the gentleman who is before the court did not sign the same, the first thing that the magistrate is going to do is determine the issue of paternity. So in that instance, what happens is the court would order a paternity test be done, or it may be a circumstance where the father just did not sign the birth certificate but is willing to accept responsibility.
Yeah.
So the court would ask, do you acknowledge that this minor child is indeed your child? If the father says yes, then the issue of paternity is solved, I guess.
It goes away.
Right. After that is rectified, the next step that the court goes through in relation to the matter before it is custody. So with custody,
before you move there, so once the father's accepted that yes, it's his child,
yes,
then I believe the magistrate would then deem that person to be
It's
the
the punitive
punitive father.
That is correct.
Likewise, if there's a paternity test,
Mhm.
and I believe that there are times when they would say if there has to be a test, there's a time and place agreed upon,
yes,
and you
between
both
parties.
share
The cost of
equally the
things.
cost.
Now, the courts actually has a list of agencies in which they would prefer the paternity test to be done.
Yes.
So the parties again would agree on which agency they would visit with the
Right.
child and the date and time in which the testing will take place. The magistrate, if at this point paternity is an issue, would adjourn the hearing till that date and time after they've gotten the result.
After they've gotten the result.
Right.
And so we have it now. So let's say we're to the point where someone's been adjudged or deemed the putative father. Now we then move on to
Custody.
before custody.
Mhm.
I think when we look at the Child Protection Act, we have to deal with the issue of maintenance. It's a hot button topic,
Mhm.
Sure.
maintenance.
Sure.
And so, we all practice in that area,
Yeah.
Right.
in terms of maintenance. Again, how is maintenance determined by the court? Angel?
Usually, the court will do an affidavit of means so that the respondent will come and say what is his expenses, and from that list, the court may determine what he can afford to pay.
So it's
ba-
pretty much based on what he can afford.
it's pretty much based on what he can afford, but it's my experience that most times the judge orders maintenance payments around $50 per week.
See? There we go. So we have then a balancing act based, in my mind, what the father can afford versus the actual needs of a child.
Yes.
And so, again, you're all parents here.
Sure.
We're all parents at this table. If you're talking about a newborn up to, let's say, 12 months, I think you would agree around $150
to $200.
$200 a
Yes.
week
Yes.
seems to be the amount. And if
yeah.
you split that in half, then you're talking then anywhere from $75 to $100 a week is perhaps a necessary sum.
Yeah.
And however, you said right off the top, it's rare to find orders going or exceeding $50.
Yeah.
Sometimes you have, I've had clients who say, "Oh, take me to court. I'm paying them $150. They don't want me paying them $150."
It's true.
So again, now, should does the law speak to the Child Protection Act speak to how the courts ought to determine how much maintenance ought to be paid? Or is it just based solely on what the father can afford?
Well, I would say that the act does not definitively state this amount should be paid. But what the court should take into consideration are the means of both parties.
Right.
So that is, as Mr. Hanschel indicated, the necessity for the affidavit of means. Now, there are instances which persons who have moved the court forward off of their own do not provide the affidavit of means.
No, they don't.
And there have been situations where the court would just ask, what can you afford? And as you indicated, you have some clients on the other side who may say, well, I can only afford $50. But in actuality, what they do not take into consideration is income is not only your salary, it's also that side hustle. It's also
The Smith Curry.
it's also the income you have from apartments.
Yes.
If you, like I said, a side hustle, wash cars, power wash,
Plumbing, electrical. People do set up a website,
Right.
Cleaning, gardening, or maintenance.
Exactly.
All of those things
So-
to supplement.
But what I have experienced is on a lot of instances, persons just look at, oh, I just work for government and
This is what I earn.
this is what I earn, and all I could afford is some of them say $20.
Yeah, yes. I've
So-
been in court where it's been as low as 20, 10. It's
Yeah.
something.
Mhm.
Is there, and again, unfortunately, you're the man in our midst, Mr. Henschel. Should the act is silent, but do you feel that there ought to be some type of, I don't know, checklist or a greater emphasis, perhaps more so on the needs of the child versus the earnings of or disclosed earnings
Yeah.
of the father?
Yeah, I think the paramount consideration should be the maintenance of the child. That has to be the number one thing that the court should look at.
Yes.
And if need be, make orders that will help maintain that child properly.
A lot of fathers just frowned at you. But when we come back, we're gonna move on now from the maintenance, and then look now briefly at the issue of custody, and then other common applications that are before the magistrate's court.
Yes.
You're watching The Legal Brief.
A new year brings a new lineup. ZNS is bringing you what you want to watch, so don't blink. What's Trending Lifestyles in the Afternoon starts out the daily programming at 4 p.m. This is followed by Unleashed at 5 p.m., a show that dives headfirst into all topics ranging from headline grabbers to current events. At 6 p.m., Grand Bahamas The Bounce Back graces the airwaves, a review of Grand Bahamas recovery. 6:30 p.m. brings the news from Grand Bahama, and 7 p.m. brings The Big Show, the new Bahamas Tonight, followed by a continuation of news with the Bahamas Tonight Access Now at 7:30 p.m. News with a new twist. Surprise, surprise! At 8 p.m., The Rundown, nightly news analysis for all of the big stories of the day. And wrapping things up at 11 p.m. is The Bahamas Tonight, bringing you fresh news. Only the sun covers the Bahamas better than ZNS.
Welcome back. You're watching The Legal Brief on ZNS TV 13. I'm your host, Ramona Farquharson, and we're discussing family applications before the magistrate's court. We've reached the natural point here. We've talked about maintenance. Now, access. Oftentimes, the unwed father is longing. I'm going to be gracious.
Yes.
Longing for access. And I'm going to just throw it out there. The courts tend to want to lean towards staying access, meaning allowing access, sleepovers.
Yes.
When we say staying access, sleepovers, alternate weekends or every weekends or through the week.
Yeah.
I want to know from you, and because again, does the Child Protection Act, even though it talks about access, does it speak as to when there should be staying access? And if so, how much staying access? Ms. Smith-Curry?
So it does not address staying access. It does not address the duration of access also. That again is something, if the parties cannot agree, it is decided by the court. Now, staying access, generally, I would say, is not something that is awarded for younger infants and babies. It is normally the view of the court that young children,
Are you hoping?
Yeah, hoping.
You're hoping.
that young children need the care of their mother during those tender age.
Usually being breastfed.
Yes.
And so when do you think that, or usually in your experience, that staying, and I come into you because I
Yes.
see you twitching, you're moving, Ms. Angela, when should staying access become applicable to an unwed father?
I would say once the child is potty trained, able to vocalize what their needs and wants or pains or grievances are, that is when staying access should be awarded to an unwed father, in my opinion, of course.
What you really want to say is when you can tell mommy what happened. Yeah, wait, mommy, I was here and then this person met me, this person didn't feed me, this person hit me. That's what you're saying.
As
You
a
feel
mother,
that, yes.
you know, and I'm speaking as a mother, when your child is not in
Your
your presence, you want to know that that child is being taken care of. And what we see during or with the applications between unwed mothers and fathers, there has been a breakdown in their relationship. That breakdown, unfortunately, means that there's no communication between the parties. So for a mother to be comfortable to know that, okay, yes, my son, my daughter was with his dad and they had something to eat, or when he fell down, he was well taken care of, things like that. A mother wants to know.
And should have a
So,
right to know. as a
right.
parent.
So, in my opinion, staying access should happen once the child is potty trained, able to communicate their needs and wants, not only to the father, but also let the mother know what's going on.
Yes, what's happening. Mr. Henshaw.
Yes. And while I appreciate that mothers want a bond with their child, I also, as a father, appreciate that good fathers, and there are a lot of us out there, want to have that same bond. We want to also know that our child is being fed. We want to know that that mother, when that child fell down, that that mother took the time to clean that cut up. We want to know that. So I would say that
Staying
very
access.
staying access that should be done very early on. And most times, like my experience in the court wants to bring up this issue about breastfeeding, and that should be an issue. But there is a way that
Oh.
women can express the breast milk and bottle it up and send it over to the husband. You put it in the freezer. It's just as good.
Father needs it.
Yeah, and the child drinks the breast milk from a bottle.
Somewhat onerous though, Miss Dan.
It's not onerous. There was a breakdown in the relationship. I
Yeah.
think we lost it. And then the
Particularly if you have
father,
to bring someone to court to pay
Yeah.
maintenance.
sure, right? There was a breakdown in the relationship. And because of that breakdown in the relationship, we can't give all the rights to the mother and say, you get all the right to nurture this child from a tender 6-month-old. And father, wait until the child's talk, and then you could get your right to take the.
Saying access, I believe, but you can have access, but
Yeah,
maybe
so-
not that sleeping over.
Right. So
Yes.
you could
But so I can't sleep with my child just because he is younger. I don't have that right to be able to cuddle that child in the middle of the night.
well during the tender age they take naps. But-
Yes.
But generally speaking, access to the child, with the unwed father, we're not saying you can't have access. It's just the overnights. Because generally speaking, how many fathers out there are going to get up 2, 3, 4 times in the middle of the night to feed a child?
There
That's
are
right.
many child. There are many fathers who are willing to do that and will be happy to do that. And then when we look at these, a lot of these unread fathers, we neglect the role of the grandmother in these situations, who usually there to help their son.
But I think that now we're getting into bringing in third parties. And
And
again,
that's
the
fine.
court can't or would not be necessarily in the position to put obligations or question third parties. They're not a party to the action.
Sure.
It's the mother and it's the father.
Sure.
And if it is a case where you're saying, I have to rely on a
Grandmother,
third
yeah.
party in order to assist me at nights with the child, then I think, of course, the mothers would chime in and say, no, send my child. Just bring my child to me rather than you having to rely, because sometimes it's not really grandmothers, is it? It's girlfriends
Yeah.
or a sister or the rest of it. And so it can get rather complicated and messy. But it's good to know, well, it's something to note that the Child Protection Act doesn't spell it out. I think leaving it as much as possible to the parties to
Work it out.
reason and work it out. And unfortunately, it falls on the magistrates if they're unable to do so. So we've dealt then with maintenance, the meager, I would say, the very meager amount of maintenance, and we're now dealing with custody or access, more so access, because custody. These words are important. Custody is very much vested with the mother,
Yes.
unless there are very stringent circumstances for the
Sure.
court to remove custody. So access, that's what we're speaking about for unwed fathers. But I also now want us to look at another type of application. And that application would be where we talk about legal separation. People think of it as the wake-up call. Legal separation. Miss Smith Curry, can you lead us in this? How do you start or commence that application before the court?
So again, this is an application similar to the maintenance order, where the party, because it could be the husband or the wife,
Yes.
they have the option to move this action forward on their own or seek legal counsel in relation to doing that. Again, the magistrate court, because it is a user-friendly court, has a form for that. So the party would fill out the form. the party would then get a summons. That summons then has to be served on the other party by a police officer. That
Or peace officer.
peace
Yes.
officer. That peace officer must then do an affidavit of service to show that the summons was actually served on that party. Again, we spoke about making sure you come
What's
to
your
court
summons?
with your summons. When that happens, the parties are brought before the court. Now, with the legal separation, the reasons for your legal separation are very much similar to the reasons for a divorce.
Mm.
So, in this regard, you're looking at adultery, cruelty, sodomy. We don't.
Yes.
Yes.
Yes. To go down that road.
Yes.
But yes, but very similar and akin to divorces.
Mhm.
And again, this segment is just blown by. Before we go, well, after we come back from the break, I want us to look at further the practical roles or that takes place when you have your legal separation. Who testifies, who responds, and then the decision making. But also to pose this question: is a legal separation on the same level as a divorce? And if not, why do people do it? Why do they go through it? You're watching The Legal Brief. I'm your host, Ramona Farquharson, and this is ZNS TV 13.
Next time on Justice with Judge Carol.
Ms. Bell just moved in about 2 weeks ago, and she has brought 3 dogs, Your Honor. And for the last 4 nights, Your Honor, I was unable to sleep. I am a pilot, and I'm sleep deprived.
First of all, I know he's a bit uncultured, as you can see. I have 3 beagles.
Your dogs don't bother you when they sing and howl at night?
No, it's honestly not that often.
Catch Justice with Judge Carol, Tuesday, 2 p.m., Wednesday at 8 p.m., right here on the ZNS Network.
You're watching The Legal Brief, and in this episode, we're discussing family applications before the magistrate's court. And we were at the point of going further or deeper into legal separations for people to understand what that means. And you'd already shared with us, you get the summons, it's served. I hate to say it, most times it's the wife who's serving the husband essentially. Fortunately, it is. And you're now before the court. What then occurs, Ms. Smith-Curry?
So what then takes place is the magistrate would have both parties, the husband and the wife, be sworn in. They have to hold the Bible.
And I smile at that point because the two of them sometimes are clutching this
Yes.
Bible. They don't even want to be next to each other. But yeah,
So
go
true.
ahead.
And after they're sworn in, the magistrate allows the applicant, so that could be the husband or the wife, to take the stand and give evidence as to why they want a legal separation from their spouse. The magistrate would hear. The magistrate gives the other party the opportunity to ask the person questions.
Cross-examine, yes.
Right. And then they, I guess you'd say, swap positions.
Yes.
And at the end of it, the magistrate then makes a determination whether or not there are sufficient grounds to grant the legal separation.
Yes.
And in some instances, there aren't any.
You think it
sufficient
be
grounds.
frivolous in some
Yes.
ways. Yes.
And like you
sometimes.
indicated, some persons just have it as a wake-up call.
Yes. I've heard it oftentimes. My clients will say to me, Ms. Farquharson, I want him to wake up and stop what he's doing. He's staying out late. He needs to know I'm in business. And so, too, Ms. Angel, is a legal separation on the same level of, let's say, a decree nisi?
If you had said decree absolute, I would have agreed that it's not on the same level. But it's probably on the same level of a decree nisi because it gives the party a wake-up call.
Yeah, in
Be-
terms of being a wake-up call,
Call,
but
yeah.
the legal gravitas, I think we'll all agree it is
Yeah.
not on
Right.
the same
No.
level of. In fact, you're still, even if you have a legal separation, you're still
married. You're still married. You're still married.
of that
You're
person.
still married, yeah.
If they don't have a will, something happens, you're still the wife. You're
Yeah.
still the husband, even though there's a legal separation. But what it does, from a legal standpoint, is it it stops the obligation on you, let's say, for conjugal kindness.
Yes.
And having to
Definitely.
cook and clean and do things that a wife or husband ought to do.
Yes.
I think as well, Ms. McCarvey, you can speak to whether there's any duration to it.
Now, in relation to that, there really is no duration.
No.
It could go on
Indefinitely.
forever. If the parties are not serious, as we indicated just a few moments ago, if one party dies, the other spouse is entitled just as though they were living together as man and wife.
Yes.
So that's why I always urge persons, if it is their intention to be separated from this individual, in order for that to actually happen legally, you need to seek and obtain a divorce.
Yes.
And not a
Normally,
decree nisi, a decree absolute.
go straight to the end.
Yes.
Yeah.
However, once you do get a decree nisi, you cease to be the heir.
Yes.
Under the Inheritance Act, you cease to be able to inherit
Mhm.
or to be the administrator of the estate.
Right.
That's the good thing about that.
Yes.
But a legal separation does not have nearly
As
a
much teeth.
teeth
Yeah.
as you moving to the Supreme Court. So just for persons to know, it's a wake up call. I think if you get served with that, then it's a period for you to determine, do I want this
What your
marriage?
intentions are,
Yeah, what do
yes.
you want this marriage? As well for persons, if they start Supreme Court proceedings, what effect does it have, you would say, on those, let's say if you're in the process, you served the summons for legal separation and the other party goes ahead and files the petition, what in fact happens to your proceedings in magistrate's court?
Well, in the magistrate's court, they won't be able to touch it anymore.
Yes.
That'll be the result if someone goes to the Supreme Court before your application in the magistrate court is heard. However, if your application in the magistrate court was already heard and a maintenance order made, that maintenance order will still go on until the Supreme Court makes a final determination.
Yes,
on
exactly.
the
So
maintenance.
still, those magistrate orders still remain in effect until the higher court makes another order that will
Yes.
supersede or take over those.
Yeah.
Certainly. So that's good for persons to know, because oftentimes I ask a question, well, he took Ms. Farquharson, what happened? He filed a petition. And then too, it's interesting because sometimes you find yourself in limbo. You've begun legal separation proceedings. You get served with a petition. At least the court is made aware
Yes.
that a petition has been filed. But there's no onus to serve that petition for at
That's-
least 12 months.
That's right.
Mhm.
You know, it's good for 12 months. So I've found sometimes that the magistrate's court will say, okay, yes, you told me there's a petition. I'm somewhat funkless
Yeah.
and with respect to that.
Yeah.
But sometimes some will say, I set a mention date
Mhm.
because I want to be
Make sure
sure that this was served. If
Yeah.
it was served, you don't have to come back. But they don't want it to just be, and then, they really can't do anything,
No.
so to speak, because it's there. But then still, it seems to still be an area where the things can be tightened up.
Yeah.
Because there can be room for abuse.
Yes.
Yes.
Yes, room for abuse, certainly, there in reference to it. So we've touched on maintenance and access, legal separations in reference to parties. But I want us now to double back and look at possible reforms, because these applications have been around for a while. Certainly, I've been calling now 21 years, and where possibly there can be room for improvement. I think we've touched on one already with the Child Protection Act. You would say, Mr. Henschel, that I think both you as well, Ms. Smith Curry, you're saying, listen, unwed fathers ought to be able to move the courts as of right, just like an unwed mother. If they want access, just move the court. They don't have to wait if they're served with maintenance or not.
Yes.
I think you would say that. But I think most persons may agree to that. But I want to throw this out here. My thought is that there should be some conditions or stipulations in place. For instance, let's say you have not maintained the child for 10 years or more. The mother, and that it being the father, the mother has moved on. She's married in a stable relationship. this child is now a child of the family with another man, but a child of the family nonetheless.
Sure.
Should you have the right to now summon that mother and assert your rights as the putative father to knock on that man's door and say, hey, bring Johnny out here. I come in here every week. I need to see Johnny. And I mean, should that happen? What are your thoughts on that, Mr. Henshaw?
I think that could happen. I think it should happen. And I would welcome fathers who've been absent in their child's life for 10 years to try to make an impact into that child's life, albeit late. I think the impact of men and their children and men taking a part in their child's life is vital.
So
to
it
the
should have
development.
any time limit on it.
I don't think it should have a time limit. However, I do believe the mother should have a right to say, to also say to the court why she doesn't believe.
He
Why
should have
he
access.
should have access after 10 years and let the court determine whether he has
Whether or
to
not they
change
should,
back,
whether or not they should grant it
Yes.
under those circumstances.
Yes.
I'm going to get your view right after the break. Things are heating up in here. You're watching The Legal Brief on ZNS TV 13. Ms. Smith-Curry, what are your views? Should an absent father for more than 10 years be allowed to assert their rights to have access to a child?
So I would just say assert seems very strong. What I would say is that a father who knows that he has been absent should be mature enough to approach the mother of his child, admit his faults. Yes, I've not been there, but I know that I can be beneficial to this child's life. And speak with the mother and see if they could come to some sort of arrangement.
But if they can't, then should he move the courts? Or should the court permit him to be able to intrude? And again, I'm using these strong words. Intrude or to come into that family dynamic where that mother has her routine. And it is not that the child is lacking. Like I said, if she's married, should the law permit that?
The law should permit him to be heard, as Mr. Hanschel said, and then make a determination once both parties have been heard whether or not the father, and I'll use your terminology, is allowed to insert himself within the family that has been created.
Right.
I don't see where it'd be any harm, but again, each circumstance is different.
You being
don't
nice.
know.
Because I been, come on now, you marry a woman and you take care of that child. You don't hear no other man knocking on that door talking about it. He wants, and it's like an obligation. Because once you have a court order, you have to produce or make the child available.
And I believe as parents, they should be mature enough to realize at the end of the day, it's what's in the best interest of the child. Yes, there is a family already.
I don't think we'd be out of work if they had all this maturity, because certainly it wouldn't be before the courts.
Yeah.
But I do hear what you're saying. Now, moving on as well to maintenance, because when I sit there and I hear the excuses why one can't afford or pay substantial, or I wouldn't say substantial, reasonable maintenance. I believe that to me, and I'm going to throw it out to you, that there needs to be reform. When there is reform to the Child Protection Act, there needs to be something standardized or a scale with respect to maintenance. Do you agree with that, Mr.
Yeah, I do agree maintenance should be different than it is now. I believe in the United States, the starting point is a third of a man's income or a woman's income. Let's want to push that in there, or a woman's income.
Predominantly here, we'd be talking about a man's income.
Predominantly here is man, but a third to go towards the first child born where the couple is separated.
Wow. Ms. Smith-Curry, your views on that? Should there be a scale, something standard?
Definitely a scale, because the average now is not adequate at all.
I think it's insulting, really.
Yeah. And I believe we had this discussion. It's not even sufficient to get lunch for the child. When you look at teenagers, they are involved in extracurricular activities,
Many.
and $50 cannot touch what is needed for the maintenance
A
of that
week.
child.
For a
Right.
week, yes.
So definitely we need to move that issue forward. There being a scale
Scale.
and say, look at for one child, this is the amount of your salary that should be allocated for that child.
Yes. And two, about collecting. Oftentimes it's what? Pay to the window,
Yes.
and then it will go to a card for the mother or to a bank account. And oftentimes I hear that, oh, the cards now, they take so much away from it. But obviously there are fees involved. So even though it's so meager, the mother is still not getting the full amount.
Yes.
So I do believe that the powers that be need to revisit this whole issue of maintenance and also how one can receive that maintenance, whether through more emphasis on salary deduction,
Yeah.
and also if you're delinquent, rather than the mother having to go back to the court to see if get the warrant pulled from warrant section, and then come on, you got to tip someone to
Sure.
pull it, tip someone, get it served. I mean, it's a nightmare, isn't it?
Go
For
around
from
to
other
account staff
go
to
around
see how much the arrears
whereas,
are.
and then time away from work. You're running up and down to get the rest to bring him back. He may only pay for a short period of time. I think that there needs to be more stringent mechanisms in place.
And if we're going to be more stringent in those mechanisms, I also think we need to be more stringent in other mechanisms in
There,
terms of
touch it
access.
before we close.
Access. You know, if you're going to if you're going to require a man to pay a certain amount, then be just as vigilant as the court to make sure when he has his access that he gets his access.
Get that full time.
He gets the full time, and when in this case the mother is being difficult and picking up the child before the order and disappearing with the child,
Don't do that.
they certainly do that. And
Don't.
it's been my experience.
Others do not.
And
do
it-
such thing.
And it's been my experience that the court tells them not to do it, and then I'm back there a couple of weeks later with the same thing. I can't find the
I
child.
cannot speak to that. I won't dare speak to that. Hasn't been my experience. I heard that from a guest of it. It's not been my experience. But again, we've just tipped. This is just the tip
Yeah,
of the iceberg.
yeah.
There's so much more bound overs and just even going even deeper into these applications. I'm
Sure.
going to have you two back again.
Thank you.
But thank you so much for joining me. And to you, our audience, you have hopefully gained greater insight into the family applications before the magistrate's court, what is necessary for you to do in order to move the courts, and once you're before the court, what practically occurs. At the end of the day, we're aware that the family, again, the cornerstone of any society, is the family. And we want to make the family stronger. And so here it is, you have body of law that is seeking to put in place rules and regulations to help us all get along. Ultimately, the welfare of the child is of paramount importance. And two, we want everybody to share alike, be fair, because once we have a strong family, we have a stronger society. Thank you for watching The Legal Brief. I'm your host, Ramona Farquharson. You're watching ZNS TV 13. Thank you for watching The Legal Brief. Be sure to like, comment, or subscribe for more.